Hello and welcome to IDR Intel with me, Stephen Lawson. Today I want to talk about three issues which have the role of the will preparer at their heart, namely the SRA thematic review, a case involving the identification of a beneficiary, and a case that may be best described as a deathbed nod to a solicitor. So, to start with the SRA thematic review, firstly, I have to say the SRA seem to have a language of their own. I've never heard of anyone talking about a thematic review, but there we are. This is the language of the SRA. And back in February, they decided to conduct a review. In fairness to them, they found that approximately 1/3 of the complaints to the legal ombudsman arose from private client work. 47% of the complaints related to inadequate client care, 23% of the complaints related to potential fraud, and 20% of the complaints related to misleading a client, perhaps about the progress of estate administration. On top of that, probate-related payouts are the largest draw on the compensation fund, where solicitors don't have insurance cover. So earlier this year, the SRA wrote to 25 firms chosen at random, and they asked them a whole load of questions and said, by the way, we're coming to visit you and we're going to talk to your head of department and we're going to look at files and we're going to look at your ledgers. So they've been and they've conducted those investigations and they've looked at those firms. And I do feel sorry for those firms because they really had no choice about it. They were large firms and small firms and high street firms and city firms and all of the rest of it. And although the review's continuing, some initial feedback is being leaked out of the SRA. Firstly, they found that most firms did well identifying the needs of vulnerable clients, but they found that all firms they looked at needed to improve their communication process with clients. They need to particularly improve information about explanations about the probate process, setting out the role of an executor, and what beneficiaries can expect from the process. Now, I've been lecturing for many years on the Inheritance Act, and the Law Society WICS scheme recommends that clients can be given a standard guide explaining about the WICS scheme. So all of these standard guides are information that can be provided by firms, which will really enhance the quality of work that they give and help to avoid complaints. At least 2 of the 25 firms are now being formally investigated by the SRA as a result of deficiencies identified. And that's why I said I really feel sorry for these firms because they were chosen at random, they were investigated, and now they're looking at potential disciplinary action. So it seems to me that all private client firms, solicitors or not, should conduct a review of their processes to make sure they continue to excel, because the world moves on, doesn't it? We've all got to change the way we do our work, and there's no doubt that we can give further information by way of standard documentation to clients. Now, for several years, I've been presenting a lecture called Will Writing Mistakes, and I went to the Association of Lifetime Lawyers in Preston just 2 weeks ago to present an in-person lecture. I was delighted to see so many people attend, and I really love presenting these lectures because, unlike a webinar, it's a real two-way process, and I always learn as much from delegates as hopefully they learn from me. But one of the mistakes that I've been lecturing about is the failure of will preparers to identify a beneficiary correctly. For example, there's the case of Florence Hart, which is a 2015 case, and I'd been lecturing about that since 2015. And in that, the solicitor included a beneficiary named the West Berkshire Ambulance Hospital, which when read literally means a hospital for ambulances. So that resulted in a court hearing to construe and identify the correct beneficiary. And then there was another case in 2020 called Knipe and British Racing Drivers Motorsport Charity. And I love that because It involved the estate of Barry Wizzo Williams. Wizzo was his nickname because he was a former professional racing driver, hence the nickname Wizzo. But again, the will preparer failed to identify relevant beneficiaries, and that also resulted in application to court. And then just very recently, we've had the latest case of Dryden and Young. This was a 2024 case, as I say. It involved the estate of Marjorie Thompson, who died in 2020. A solicitor drew up her will, and she left the residue of her estate to 15 organisations or charities. 15. 7 of the 15 organisations or charities were wrongly identified. So that resulted in a court case as well, with consequent costs orders. So please heed my words. Any professional will preparer who draws up a will and simply writes down what a client says about the identity of a beneficiary, particularly a charity beneficiary or particularly an organisation, is at risk of having a cost order being made against them when the inevitable application for the construction of a will is made. So it's always useful to check the charity register and discuss issues arising with a client. So lesson 2, if you like, today is identification of a beneficiary as evidenced by 3 cases. Incidentally, we've written articles about this. All the written details and the case citations will appear in our notes, our written notes on the IDR Intel page. The last case that I want to talk about is the recent case of Crewe and Oakley. Judgment was only handed down as recently as the 15th of November by Deputy Master Linwood, and this case was widely reported under the heading Deathbed Nod to Solicitor to Tear Up Will Accepted by a Court, because what happened there was that a solicitor helped an elderly and ill, she was in hospital, testatrix to tear up a will. The solicitor put her hands on the testatrix's hands and helped to tear the will. And the issue was whether that action complied with Section 20 of the Wills Act 1837. Because if a will's destroyed by someone other than the testator, then it must be destroyed in their presence, by their direction, with the intention of revoking it. And the issue in this case was whether the nod, if you like, constituted a direction to revoke the will. And the judge found that the nod was indeed sufficient authority. And it was quite an extraordinary case because despite the eye-catching headline, there was much beneath the surface of the judgment. It's clear that the test of capacity to revoke a will is the same as the test of capacity to make a will, namely the Banks and Goodfellow test. But what was unusual in this case was that although the will preparer found the testatrix had capacity to revoke a will, she didn't have capacity to make one, which was the whole purpose of the visit in the first place. So the will preparer made a decent file note. She accepted that it could have been a better file note than it was, but it was helpful to have included that, a detailed file note. So file notes are always your best defense. But there were other issues in the case because the hospital records said that the testatrix in fact lacked capacity to make various decisions, and an expert produced a joint report for both sides in the case, an expert psychiatrist, Dr. Hugh Series, who's very experienced at these things. He found that the testatrix lacked capacity to revoke the will. But despite his finding, the judge preferred the evidence of the will preparer. So that really demonstrates the importance of will preparers to the whole process. Your evidence is key, and to use a current phrase, trumps all. So thanks very much for listening. You'll see the notes on the IDR Intel website, and I hope to see you again because we've got much more exciting information to come. Bye-bye.